Good morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime Live. This is where we cover some of the most interesting live trials in the country today, and we have a really exciting live trial for you today. It's the William Knight case out of Ohio. We're entering into another day in this case. The state is still continuing their case in this man, William Knight, who is charged with shooting and killing an unarmed man named Keith Johnson after recovery of a dirt bike went wrong. That's right. Mr. Knight has a son-in-law named Curtis Gill who was trying to recover his dirt bike that he thought was stolen from him. Tried to recover from Keith Johnson, who didn't steal the dirt bike, but did know that it was stolen. There was an altercation on trying to get the bike back. Shots were fired, and Mr. Johnson was shot right in the head and died on impact. Died right there in the scene. Now, here's the question. Was this murder? Or was this self-defense? Because the defense is saying that's what this was. Mr. Knight was trying to protect his family. Because according to the account, Mr. Johnson got back up on that dirt bike and drove it at a high rate of speed towards Knight's family. It was Knight's son-in-law and his daughter were also at the crime scene as well. Mr. Knight is on trial. He faces murder charges as well as felonious assault charges. So we have to try to understand what happened here. Now, I am keeping a very careful eye on the courtroom. I'm looking at it right now. As soon as there is a live feed in the courtroom, I'll make sure to go to it. I don't want you to miss anything. But there's a lot to talk about what happened yesterday, as well as the overall theme in this case, the self-defense theme. So let me bring in my special guest for this morning, criminal defense attorney Brian Wagner. Brian, good to see you.
Good to see you. Thank you for having me.
I don't even know where to begin, but I'll start with, let's talk about the self-defense standard here, okay? Because yesterday, due to a scheduling issue, one of the defense's witnesses was brought in, a Dr. Lee Brahms, to talk about the psychology of William Knight. Who was this guy? What was going on in his mind? Is that the standard, what's going on in his mind?
Well, in Ohio, it's important to remember that, unlike in other states where the defense never has the burden, in Ohio, the defense actually does have the burden. They have to prove, when they're asserting self-defense, that the defendant acted in self-defense. And so when you put in that psychologist, it does help illuminate what he, Mr. Knight, actually thought, because it's a subjective standard, meaning what did Mr. Knight think at that very moment. What they need to prove is that he did not create the dangerous situation, that he acted in real fear for his life, what he perceived as fear.
Or for his family's life.
Or for his family, in this case his family, correct. And finally, that he didn't violate the duty to retreat. That's where I think the self-defense is going to really have some trouble.
I'm going to ask you some things that the prosecution have said. They said he was the one who came to the house, okay? So they were the ones who initiated this. They're the ones who tried to recover the bike. Now, did he, in your opinion, go into a tactical position by parking his car down the street? Because also you have to remember, he had a concealed carry permit. He had a license, a right to carry a gun, okay? He could carry a gun into the supermarket. He could carry a gun to dinner. He could carry a gun when he went to there. So every time he goes to a situation, is it fair to say that he was in a tactical position?
Well, no. So that's where the prosecution can overreach. If they say he created the dangerous situation by merely going to confront the person that had his stolen dirt bike, they're going to fail. If what they're saying is that, no, he went, and then once the situation was kind of de-escalated at the house, he ramped it up, then they're going to have to really rely on eyewitness testimony. What did the daughter actually see? What did the son-in-law actually see at the time? And what did the forensic evidence tell us? So it's in the seconds before the shooting occurred that you care about who created that dangerous situation, not the global overall dangerous situation.
You have an unarmed man. Well, I should say, let's cut it down here, okay? Mm-hmm. You have an unarmed black man and an armed white man. There is a lot of racial tensions, including the fact that when Mr. Knight was arrested, he was first charged with involuntary manslaughter. Those charges were up to murder. How is it possible that he could have a self-defense argument if he had a gun and Keith Johnson didn't have any weapon on him? Do you count the dirt bike as a weapon?
Well, no. What you're really looking at is what did Mr. Knight actually think was occurring? Because that's the standard. It's a subjective standard. And so if Mr. Knight, in that moment, right before he shot him, really did think, I am in fear of my life or my family's life, and that this is a deadly weapon, the motorbike or the dirt bike coming at my family can cause serious physical harm, if not death. At that point, if he truly believed it and the other factors are satisfied, that he didn't create the situation and he didn't violate a duty to retreat, then he can prove self-defense.
Isn't it a reasonable person, though? So in other words, isn't it the idea that if we just take what everybody says, oh, I thought I was in danger, we'll just take your word for it. But isn't it, no, what would somebody in that position who had a reasonable perception of the events, the circumstances, what they were going through, what would a reasonable person have done? Because here's the thing that I think is strongest in his case, is he fired that warning shot. Okay, the first shot wasn't the deadly shot, it was a warning shot. Would you, as the defense attorney, really try to hit on that point?
That he fired a warning shot?
Yeah.
To me, that doesn't really come into play. If I'm the defense attorney, what I'm trying to establish is that the motorbike, or the dirt bike rather, is coming right at his family. And that it's coming right at his family, and based on that, as you said, a reasonable person, forget about Mr. Knight, would think, oh my God, my family's about to get killed by this guy. Then at that point, you could argue that he's justified or acting in self-defense. But again, it's those the devil's in the details is the expression.
Yep.
The devil is in those details.
Okay, well, let's look a little bit more about the testimony from yesterday. This is Dr. Lee Brahms. A defense witness had to be called in during the prosecution's case because of a scheduling issue. She couldn't make it later in the trial. Listen very carefully to what she says. We're going to play you her testimony. We're trying to get into the mind of William Knight. Take a look.
And I think you could look back at anyone's life, and that's pretty formulaic, but it's true. So I need to understand how his personality was formed. How did he learn to make judgments? How does he perceive the world? What are his social skills? What has been his impulse control over time? All of those things. And what impacted him morally, socially, developmentally in the early years of his life. Okay. So what we have here is a child who was socially unskilled, extremely nervous. I can't go back and diagnose someone 65 years ago, but I believe he would have met a criteria from what I hear of having an anxiety disorder at a minimum as a child. So that is what he was like as a child. He was basically given little direction, probably abused to some degree, socially inept, and that was what he was like as a little boy. As he became a teenager, he tried to tell me he'd stand up for himself, but the manner in which he shared it was very almost hapless and pathetic. You know, he kept telling me I knew how to fight for myself, but the manner in which he shared this, he was trying to show me he could be a man, but he was just fairly passive and naive.
Judge, a housekeeping matter. Based upon the doctor's training, education, and experience, I would ask that the court allow her to testify as an expert in her field.
Any objection?
No objection.
I will find that the doctor is qualified as an expert.
Let's try to understand a little bit about what's going on with Mr. Knight here and whether or not he is qualified for a self-defense argument. Again, I'm here with Brian Wagner. Okay, so he had to wear a bow tie to school. That means he's allowed to kill someone?
I think that's a stretch. I don't think that's what she's actually saying. But what she's trying to establish now is that she was able to have a competent interview with him and that you should trust her findings. All they're doing at that point is they're voir dire, basically establishing that she could be an expert that the jury can actually look to for opinions as opposed to just eyewitness facts.
Okay, so if he had a difficult upbringing, and we're going to continue playing her testimony, and he is a guy, from all accounts, from everybody who, when we watched that testimony from yesterday, he didn't have an easy upbringing. He was very afraid. He was very anxious. He was very protective of his family. He loses his wife of over 40 years, the only woman he's ever been with, and he's very protective of his daughter. His dream, and we're going to play that, is to go to a Cleveland Indians game, and he was afraid to go. So if you have a guy who's really afraid in society, I mean, there's a separate question of whether or not he should have a gun, but he did have a gun. He was trying to protect himself. And you take that into the account. Do you think that's effective here to show this is a guy that was really afraid of everything, and you put him in a situation where his family might be in danger?
I think it's incredibly effective. As a defense attorney, what I'm always afraid of is that the jury is just going to see the terrible thing my client is accused of doing. In this case, all the jury is going to hear about is that this young man, African-American, Mr. Johnson, is murdered. He's dead. He's never going to be able to go to a Cleveland game, even if he wants to, unlike Mr. Knight. And so what does this witness do? Humanizes the defendant, humanizes the client, so that each juror in that jury box can now say, you know what? It's not just about the murder. It's also about his upbringing. And whether or not it's effective in terms of defeating or proven a self-defense, maybe it gives them a second for the jury to think and say, you know, who is Mr. Knight the man? And so for that purpose, it's extremely effective. Whether or not it proves self-defense, who knows? Let's see how it goes. But it is very effective to humanize it.
Trying to understand William Knight, the man, is really a key part in this trial, and we're going to continue showing you this trial. Again, we are waiting for a live feed in the courtroom. I'm looking at the court right now. I see there's a still camera image right there in the courtroom. The court hasn't started yet, but as soon as trial begins, we will make sure to go. We want to be live. We don't want you to miss anything. Now, before we go back into the William Knight case and show you the rest of the testimony from this psychologist, I want to talk to you about some other cases that we're covering here on Law and Crime. Starting on Monday, we're going to begin again back in Atlanta in the case of Tex MacGyver. This is that prominent attorney who is on trial for shooting and killing his wife, Diane MacGyver, shot her from the backseat of a moving car. But he is claiming that it was all a tragic accident, while the prosecution is saying it was an intentional murder, that he wanted to kill his wife, mostly for financial gain. She was the breadwinner in that relationship. She was worth a lot of money. She was running a lot of businesses. His financial situation was deteriorating, and you can kind of hear what the prosecution's doing there. But we will continue playing that case for you on Monday. They were in break all this week. We can't wait for it to come back because it's so truly an amazing case, a case that's different from things that you've seen, a case where we can't say one way or another which way the jury will go. Will they see this as an accident? Will they see this as murder? Will they see this maybe as a lesser charge? Maybe he'll be charged, the jury can find him guilty of manslaughter, so a reckless homicide. It can go a number of different ways, and we don't want you to miss anything. We will cover it for you on Monday. Let's go back. There's another case I want to talk to you about that'll be starting next week. A little bit different than things we've covered here on Law and Crime, and we're very excited about it. It is the case of Gavin Cox versus David Copperfield and the MGM Grand. That's right, a man who was injured during magician David Copperfield's show in Las Vegas. He was injured during one of these tricks, is now suing David Copperfield and MGM Grand. He said he suffered numerous injuries and severe injuries. But that's not the only interesting tidbit about this case, because during this case, it is possible we may learn some of David Copperfield's magic tricks, and who doesn't want that? I know I do. We have a short preview right now of that case. Take a look.
World-famous illusionist David Copperfield might be forced to break the cardinal rule of magic and reveal the secrets of his illusions in open court. Copperfield is being sued in Las Vegas civil court by 57-year-old Gavin Cox, who claims he was injured during a 2013 Copperfield show in Las Vegas. The British tourist who once cooked for British royalty claims he fell and struck his head on the ground after tripping over construction debris as one of Copperfield's assistants whisked him and other audience members through a dark, secret passageway during the disappearing stunt. Cox claims he suffered brain trauma and is forced to wear an oxygen lung at night because he stops breathing when he's asleep. He's seeking punitive damages from Copperfield and MGM for alleged negligence. The illusionist and hotel strongly deny all claims, stating Cox's injuries were pre-existing and or unrelated medical conditions. This is Aaron Keller for the Law and Crime Network.
It's a good one. It's a good one. I can't wait to watch it. We're going to be covering it here on Law and Crime, and I can guarantee you that's not one you want to miss. Who doesn't want to learn a good magic trick? So we will cover that one. As soon as we have an update, we'll make sure to share it with you. Now let's go back to Ohio. We're in the William Knight case. I'm looking at the courtroom right now. We just heard a report, and this is what we just heard, that the judge said that when the jury comes back into that Ohio courtroom, the state is going to formally rest. Think about that for a second. So let's talk about this with criminal defense attorney Brian Wagner. Okay, Brian, rest? Do you think they put on their whole case? What do we know? We had officers testify. We had a medical examiner testify. We had a couple of eyewitnesses testify. I guess that's it.
I mean, I guess. I would be nervous if I was the prosecution. I was resting on that case. Because, again, for me, this case lives and dies on the seconds before Mr. Knight fired his gun. And so what I would want to establish is, what did the son-in-law actually see? What did the daughter actually see at the seconds before Mr. Knight fired that weapon? Because if the bike is heading away from them, I don't think you have self-defense.
Why would the state wait for maybe the defense to call these witnesses, the son-in-law, the daughter, as opposed to them calling them themselves?
Well, unlike in many other states, Ohio, the self-defense law is that the defendant, the accused, bears the burden.
Right.
Typically, in other states, what happens is the prosecution has to overcome a self-defense charge once the defense has put forward enough evidence. So maybe the prosecution is thinking, well, it's the defense's burden, let them prove their case and we'll just whittle away at it. That's fine, but it's also a dangerous game to play, I think.
It's a dangerous game to play considering the fact that the medical examiner admitted on the stand yesterday, under direct examination by the state, we don't know which way Mr. Johnson's head was tilted. Could have been down, could have been up, which means there's a number of different ways he could have been shot, meaning if he's driving, maybe his head was tilted, maybe his head was turned away. So in other words, if you say there's a million different ways his head could have been positioned by the way that bullet went in, it leads that there might be reasonable doubt there. So they left that in the air, but again, like you said, it's really up for the defense to show that this is self-defense.
Yeah. I guess the prosecution is thinking, let's not overcomplicate this.
Right.
Let's just leave it as someone died, we know it was Mr. Knight. That's what we need to prove beyond a reasonable doubt. Let the defense suggest and prove their case that it was acted in self-defense, and we'll cross-examine their witnesses and see how it goes.
Right. Okay, well, let's see. Before we go live into the courtroom again, I want to continue playing for you the testimony of Dr. Lee Brahms, a clinical psychologist that evaluated the defendant in this case. Take a look.
Thank you, Your Honor.
Doctor, moving along chronologically, can we move on to, if I can call it, either teenage years or middle adulthood?
Certainly.
What did you find then?
Well, Mr. Knight had been married to his wife Karen for 40-plus years. Karen was the first woman that he ever really met or spoke to, much less dated, and he was a very loyal husband throughout the course of the marriage. Mr. Knight has worked semi-skilled jobs throughout his life. He was a laborer, a construction worker for the majority of his life, sometimes working for a company, sometimes doing odd jobs here and there. He also has a grandson who's a teenager named Seth, and according to what I can find out, Seth seems to have somewhat similar problems that Mr. Knight did as a child. Very anxious, he's being homeschooled, he seems to have some problems, and Mr. Knight feels, of course, very worried and protective about Seth as well. So he was the best father he can be, but this is not a gentleman with a great deal of great problem-solving abilities. I hate to say this in front of him, he's not highly intelligent. He's a very anxious, rigid, kind of simplistic individual.
What did you discover, if anything, about his, let's say, his latter adult years or maybe the last 15 years?
Well, as I noted, the last 15 years are one in which his role was to be a protector.
Let me stop you there. How old is Mr. Knight?
He's in his early 60s.
Okay. I would suggest he was 63 in March of 2017. Would that sound about right?
Yeah, that's correct.
Okay.
Yes.
He's about 64 now?
Yes. Okay. I didn't know he was 63 or 64, and I was sitting here trying to guess his birthday.
Okay, so Mr. Knight is a simple, not really intelligent, or not highly intelligent man who suffers from various levels of anxiety, and he's afraid of a lot of different things. He's worried about his family, tried to protect his family. Will that play well here in the self-defense case in Ohio? Brian, what do you think about those facts that he is not a highly intelligent man, had a gun, placed in a situation where his family is now his most important thing in the world, considering his wife is no longer there? Can you start to reason what happened?
Yeah, I think that testimony is very helpful for the defense. I think one of the things she said was, he's not a great problem solver. That's what self-defense is about. The duty to retreat. I could leave, I could run away. That's what an intelligent problem solver would think. He's not that.
So let me play devil's advocate here. Why should he why should he have had a gun? Why should we take people who are not intelligent, who are simple, who are afraid of a lot of different things? Why should we care? He had a gun. Why he had one, maybe that's a whole different conversation about why he should have been had a gun. But then again, he didn't suffer from any diagnosed mental diseases or defects. But here's the thing. Everybody has issues. Everybody's got problems. Everybody suffers from different things here or there. Nobody's perfect. Why do we care?
So in terms of the gun, that's definitely an issue for another day, right? I mean, the legislator can do whatever they want to do, and that's what the law is going to be. But if I'm the judge presiding over the trial, I'm not letting either side go anywhere near that, because that's not the issue.
Right.
The issue is whether or not he acted in self-defense and whether or not he violated any duty to retreat. And so in terms of those issues, it goes back to what we've been talking about over and over, the immediate facts before and whether or not he created the dangerous situation.
Okay, but here's the thing. You have a man, then how come every father or, how come every father or every family member who's trying to protect their family, why can't they take out a gun and shoot who they believe is a threat? I mean, isn't that the question? Because everybody loves their family. Family's the most important thing. He happens to be in a situation where his wife passed away. He's a widower. I'm sure there's a lot of people in that situation, but why do we, if we allow this as a blanket statement that he has certain issues and his family's so important to him, where do you draw the line?
Well, so, because that's not the law. The law in Ohio is that a person has reasonable ground to truly believe. So, for example, if you're walking away, I can't shoot you in the back and say, it was a danger to my family. And I really, even if I really truly believe it, that's not a good defense. Because a reasonable person would say, that's not reasonable. So, if you're coming at me, and you're about to hit me with deadly physical force and I shoot you, that's a little bit different. Then a jury might say, you know, we agree or we disagree. But there's two very big extremes there.
Right. Okay. Let me ask you another question before we go back to testimony of Lee Brahms, Dr. Lee Brahms. We can't forget that Keith Johnson was an African American. We know that Mr. Knight is white. Couldn't you say, and I know that she's grilled upon that in cross-examination if she ever asked him about his racial predilections, but again, that seems to be a big issue here with this case. He's a white guy, he had a gun, he was the armed one, and it resulted in the death of a young black man. So do you think that added to the factor in his mind, maybe?
You know, I don't know why that cross-examination was there. I'm sure the prosecution had a reason for asking it. It wasn't just out of the blue. My guess is they either have their own expert that they're going to call on a rebuttal case, or they have some fair comment for summation that they want to kind of interweave throughout their argument. But I am interested to see how that plays out at a later date, because at this time, we really don't know why that cross-examination was there, but I'm sure it was there for a reason.
Right. Okay, everybody, as we wait for the live feed in the William Knight case to continue, I want to continue playing for you the testimony of Dr. Lee Brahms. Take a look.
And those...
Now, I don't know about you guys, but I love that witness. He was great. Gerald Bench, a witness who actually was there right before the shooting took place, even heard the pops. Man, let's just talk to Brian Wagner real quick as this next witness comes on the stand. Brian, what did you make of this witness? I thought it was fantastic.
I also thought it was fantastic. I thought the prosecution did a great job crossing him and making him his witness, and that's their problem. They should have called him on their direct case. And instead, the defense called him, and that's a problem for the prosecution.
Well, you heard, he goes, this is Akron, you know, there's stolen bikes all the time, but I wouldn't have left it. That's $5,000 on the street right there. I wouldn't have left it if I was Curtis Gill.
Importantly, though, he said everyone could have left.
That's true.
Left.
That's going to resonate, I think, in the minds of the jurors. Let's listen into the next witness who's on the stand in the William Knight case.
He goes down, and instead at that point going, okay, man, this is getting out of control, right? And just get in your truck, because he was further away from you than you were to the door to your truck, right?
Yes.
Matter of fact.
This is some really good testimony, ladies and gentlemen. I just want to sign off our guest for this morning, Brian Wagner. Brian, final thoughts as we're listening to Curtis Gill, both on direct and now under cross-examination.
His testimony is going to be very important. His testimony is going to tell you what happened in those minutes and seconds right before Mr. Knight fired that gun. So his testimony is going to be the linchpin.
And the question is, was this self-defense? Was there a danger? Not entirely clear. Brian, thanks so much for joining us.
Thank you so much for having me.
Of course. All right, everybody, let's go back into the courtroom.